Hello, I'm Harshvardhan. Today we are going to discuss a topic in Transfer of Properties Act 1882, where the topic is gifts, which is defined in Chapter 7, and the gifts definition is given in Section 122 of TP Act. Okay, now let us know what is the definition of the gift and the transfer of how affected and anonymous gifts and who is donee, who is donor, and we will get into the topic. First, basically, before going to the definition, let us know some basic concepts: who is donor, who is donee, and what is donative intention, and what is without consideration and voluntary. Okay, so what is meant by donor and donee? Okay, who is donor? Donor is the person who is having a intention to transfer his title to the donee. Okay, any to transfer his title in any existing property and any tangible property only. Okay, then only it comes under the term called gifts. Okay, so let us discuss who is donee, the person who accepts the gift which is given by the donor, who accepts the rights in the property which is given by the donor. He is called donee. Okay, and donative intention, the donor should always have donative intention for without consideration, and he should be voluntarily transfer his property, transfer his title in the property to the donee. Okay, so let us go into the act. What act says, what is the definition of gift? Okay, in section 122 the definition of the gift is defined. Okay, let us see what is the definition of the gift. In section 120, gift is a transfer of certain movable or immovable property made voluntarily or without consideration. Keep an underline mark there, because it is really very important. Made voluntarily and without consideration. If it is with consideration, then it will turn into sale. So the gift, the primary element which we have to see if it is a gift or not, it should be made voluntarily and it should be without consideration. Okay, by one person called the donor and the other person called the donee who accepts the gift. Okay, such acceptance must be made during the lifetime of the donor and while it is still capable in giving. Okay, this is the definition given in the act in section 122 for essentials of gift. So what are the essential elements of gift? If we want to say it is a gift, what are the essentials we have to see? So there should be an absence of consideration, there should be donor, there should be donee, and there should be a subject matter, and always the gift should be existing property and it should be immovable property or movable property, and it is tangible only. Okay, and later there should be a donative intention for the donor and delivery to the donee and acceptance by the donee. So here we see the seven elements. What are the absence of consideration, donor, donee, and existing property, donative intention, acceptance by donee, and the delivery to the donee. These are the seven ingredients which we have to keep in mind while we are reading the definition of the gift. Okay, so now let us go into the section 123, how transfer affected. Okay, now the purpose of making a gift of immovable property, the transfer should be registered. Okay, what section 123 says in gifts is, for the purpose of making a gift of immovable property, the transfer must be effected by a registered instrument. Always the immovable property which is above rupees 100 should be registered. Okay, so a registered instrument signed by or on behalf of the donor and attested by at least two witnesses, and the registered instrument, as we all know, it should be attested by at least two witnesses. Okay, so later on, for the purpose of movable property, now immovable property, it should be registered if the amount is above 100. So for immovable property, it should be registered. Now for movable property, for the purpose of making a gift of movable property may be affected either by registered or by a transfer. It just mere transfer is enough for a movable property. There is no need of registration and all for a movable property as a part. If we want, we can register it. There is no compulsion to register for a movable property. Okay, so this is what section 123 says, how the transfer should be affected. Basic principle relating to gift is, once a gift is always a gift. The owner has no right to revoke the gift or unilaterally. It is a settled law. It must be cancelled by way of filing a suit in civil court by undue influence, coercion, or likewise. Only in that case the gift can be revoked. In any other cases the gift cannot be revoked. Okay, once a gift is always a gift. It is a settled law. Okay, so it is a settled law. For a conditional, only a conditional gift can be cancelled by mere subsequent conduct of donee will not entitle donor to cancel the gift. Okay, even a property was entrusted at the time of marriage. Even the property in some states in India, where like Andhra Pradesh, Telangana, there while the doctor is getting married, there will be a transfer of properties like paspu kunkuma and all. That also should be registered, and this should be registered. Okay, so later on, let us see the differentiation between the gift and a will. Okay, the main thing which we have to keep in mind while differentiating the gift and will, the title should be transferred as soon as the registration or as soon as the execution. But in will, the title may not be transferred. The title will not be transferred as soon as by mere construction of a deed. So the main difference between the gift and deed will is title. So the title should be transferred as soon as the gift is executed. Okay, so title of the document is not at all criteria the said document is a gift or will. Gift cannot be revoked. Once a gift is always a gift, and by will it can be revoked at any time, any in the lifetime of the executant. Okay, so let us go into section 124, where section 124 of the TP Act, Transfer of Property Act, defines about gift of existing and future property. Gift of existing, I mean the present property and the future property. So a gift compromising both existing and future property. While writing a gift deed, they kept like it is existing and future property. So what the definition says is, a gift compromising both existing and future property is void as to the latter. I mean, what is latter? In future what you are getting, that will be void. Okay, the only the existing property will be good, and the property which is maybe attained in future will be void. Okay, it is bad. Only it will be considered the property which is at present will be good. Okay, now let us go into section 125, gift to several of whom does not accept. So what the definition says, we will read first. A gift of a thing to two or more donees of whom one does not accept. One person, there are several donees. I mean, the donor is giving to several donees, in which one person is not accepting. So is void as to the interest which he would have taken had he accepted. Is void as to the interest. Only that person's interest will be void. Okay, scope, where a gift is made to two or more persons, this section intends that the donee would take the property as tenants in common, each donee getting a distinct share in property. Each donee, I mean the several donees, will get distinct shares, separate shares in the property. If one donee who is in the property is a not acceptance would make the gift void only in respect of his intended share. These separate shares, if one donee is not accepting his gift, then his share, only the share which he has interest, will be void. And this section, that a gift is a personal to the donee, and therefore is a gift is made to two persons jointly, and one of them does not accept, the other cannot take the whole, and the remaining persons cannot have the right on the property which is the donee who has no interest on that. The other persons cannot take interest on that property. So it will be like tenants in common, it will be like partition. Okay. And the other persons who accept the gift, they can accept the gift. The person who don't accept the gift, only that part will be left. Okay. So this is written under section 125. We will see section 126, when a gift may be suspended or revoked. The donor and donee may agree that on happening of any specified event which does not depend on the will of the donor, which does not depend, here you have to keep an underline for that word, which does not depend on the will of the donor, a gift shall be suspended or revoked. So there must be a specified event which does not depend on the will of the donor. Okay. And but a gift which the parties agree shall be revocable wholly or partly. Okay. At the mere will of the donor is void wholly or partly, as can be, as the case may be. Okay. A gift may also be revoked in any of the cases in which, if it was a contract, it might be rescinded. Okay. A gift may also be revoked in any of the cases in which, if it were a contract, it may be rescinded. Nothing contained in this section shall be deemed to affect the rights of transferee for the consideration. So it merely says that any specified event which does not depend on the will of the donee, okay, mere will of the donee, then it can be revoked. If it is there is nothing, but is only a mere will of donor to cancel the gift, then it cannot be revoked. Okay. So this point should be kept in mind. This is what section 126 says. And let us discuss about 127, which is an important topic, is anonymous gifts. Let us see what the act says. When a gift is in a form of a single transfer to a same person of several things. So let us know what it is for with an example. Okay. Anonymous gift, suppose there are two persons, one is donor and donee, as you all know. So if donor is giving has multiple properties, like two or three properties, and for one property there is a liability. Okay. So if he transfers the three properties at the same time, at the same registration, I mean three properties combinedly registering to the donee, then the donee has no right to say, I want only two properties, and the third property which has liability I don't want. So if he want to reject the gift, he should reject overall. He cannot accept only the gains, and he cannot reject the liability. Okay. So if there is an exemption for this also, where a gift is in form of two or more independent transfers. If the same example, if the donor is having multiple properties and he is registering the properties one by one, I mean 1 2 3, the third property has a liability. If he is registering first property once and second property once to the same person, same donee, and third property at one time, he can accept the first one and second one, and he can reject the third one while registration. Okay. While making an gift deed. Okay. So while making them independent transfers, while making it as independent transfers, then he can reject. While making it combinedly, he cannot reject, he have to accept all the gifts. Okay. So now let us go into the topic universal donee, what the section 128 says. Let us see the bare act first, I mean let us see the act first. what act defines it. Subjected to the provisions of section 127, when a gift consists of donor's whole property, the donee is personally liable for the debts due by and liability of the donor at the time of the gift to the extent of the property compromised in. Now let us see with an example. See, if a donor transfers his property to a donee, he is subjected to have clear the liabilities also. But the thing which is very important here we have to note in this section is to the extent of the property compromised therein. Suppose the property which is worth of 10 lakhs, the transfer has been done by the donor to the donee. Okay, that donee is responsible for only for that liability of 10 lakhs only, and later on if it is a 15 lakhs also, he is liable for only 10 lakhs of liability only, which is the property which he gets from the donor. Only for that he has a liability. Okay, so it is what universal loan in section 128 says. And this is all about gifts. And we can discuss about possession here, where which is very important point. We will all have a doubt in while reading a gift is the two topics. One is what is meant by, what is the differentiation between the gift and a will, and the other thing is the possession should be transferred while the transferring of the title only, or the possession may not be transferred. Okay, here we can refer to two case laws, the two main important case laws where which is contradictory to the other. One is Mangalal Thekkar versus Mangalal Thekkar, where the decision was laid out in 1996 to SEC 617. Okay, where in that we can see that execution of a registered gift deed, acceptance of a gift, and delivery of the property together made the gift complete. Okay, together made the gift complete. So the delivery should be there, and the delivery of the property should be there, and the title also should be transferred, and the delivery also should be transferred. This is what says in the decision in 1996 in Mangalal Thekkar's case. But afterwards the decision in Rajamma's case in 2014, where Renikuntla Rajamma versus Sarveswaramma, it is 2014 3 ACJ 113 SC, where the transfer of possession of property covered by registered instrument of gift duly signed by donor and attested as required, and it is a valid. There is no provision in law that ownership in property cannot be gifted without the transfer of possession of the property. There is no provision in law where ownership of property cannot be transferred with possession of the property. So okay, here what the decision says is the title can be transferred at the registration, which is a main important ingredient to make it as a gift. The title should be transferred at the time of the registration. Okay, but mere possession transfer can be at any time. Okay, when in conditional gifts also the title will be transferred at the same time, and the possession of the property will be after the death of the donor, or it will be a conditional gift, then also it will be registered, and then it will be a gift only. Okay, we can consider that the possession can be transferred later on time also, but the title should be transferred at the same time where it is the gift is transferred. Okay, I mean when the gift is executed or when the gift is registered. So this is all about gifts. Thank you.